Hello, everyone. My name is Rebecca, and I'm an event planner with the Orange County Library System. Welcome to tonight's virtual event, Ask a Lawyer, presented by the Orange County Bar Association. This project was made possible in part by the Institute of Museum and Library Services. In tonight's event, you will have the opportunity to speak with a panel of attorneys to get insight and guidance on family law. Before we begin, I would like to share a couple things about Zoom. Please keep in mind everyone's videos besides our speakers will be turned off. You will be muted unless you are asking a question, and then you may unmute yourself. If you have a question and you would like to speak, please use the raise your hand feature if you click on reactions located at the bottom of your screen. Also at the bottom of your screen, you'll see a chat feature. You can also use the chat and write your name or say that you'd like to ask a question so that you could be added to that list of who will be next. All right, I will be ordering from 1 to whatever number we have of whose turn it will be to ask a question. Please respect others and wait to be called on. We want to avoid people speaking out unless it's your turn. If you speak out of turn, you will be muted. For those of you who are calling in, if you would like to speak, please press the unmute button and we will see it and we will add you to the numbered list of who to call on next. Once myself or the moderator calls on you, then you may speak. Without further ado, I'd like to go ahead and introduce our moderator for tonight's event, Michael Morris. Thank you so much for joining us. I'm going to go ahead and turn it over to you.
Okay, thank you, Rebecca. Good evening, everyone. My name is Michael Morris. I'm from the law office of Michael E. Morris. I do practice family law here in Orange County, and I am a member of the Orange County Bar Association. I'd like to thank you all for attending our Ask a Lawyer event sponsored by the Orange County Bar Association and the Orange County Clerk of Courts. Before we do get started, allow me to kind of give you a little background about the Orange County Bar. The association has been around for 85 years. In addition to serving the needs of our members, one of our goals has been to reach out into the community and provide services and programs that will benefit Central Floridians. Some of our programs include our members' pro bono work with the Legal Aid Society of the Orange County Bar Association, our lawyer referral and information service, our Law Week program for school children in Orange County, and our free citizen dispute and family law mediation programs. The citizen dispute and family law mediations are facilitated by impartial professional mediators who listen to both parties and encourage a resolution that is satisfactory to both parties. By reaching a settlement, both parties avoid court costs and the uncertainty of a trial outcome. This is a free program for anyone that does reside in Orange County. Tonight's Ask a Lawyer event is just one of those programs that we do have, and we hope you feel free to ask any question you have about family law. Orange County Bar attorneys Lauren Breska of Breska Law and Michael Ferrin of Anderson and Ferrin, attorneys at Law PA, will help guide you through some of the issues that you want to know about. Tonight's event will be recorded, as you've been told, and shared on the Orange County Bar Association's Facebook page, and that link is in the chat, as you've been told. Please be sure to like the page if you are on Facebook. I did want to double check, is Roberta Walton on the call? Yes, she is. Okay. I would now like to introduce Roberta Walton. Ms. Walton is the inaugural manager for the Self-Help Center and the operations manager for the Orange County Clerk of Courts Family Services Division. As the Self-Help Center manager, she oversees services offered to self-represented litigants interested in family law, landlord-tenant law, and small claims cases, to include attorney consultations offered in collaboration with the Orange County Bar Association. And with that, I'm going to turn it over to Ms. Walton. And I believe you'll have about 15 minutes to go through your presentation and questions. Thank you.
Thank you so much, Mr. Morris. I really appreciate it. Is everybody seeing my screen?
Yes.
All right, great. I'm not so techie, so I'm always hope. So
yes.
Again, Thank you for the wonderful introduction. My name is Roberta Walton, and I am the General Counsel for the Orange County Clerk of Courts. I really wanted to just chime in tonight to talk to you all about the wonderful program the Orange County Clerk of Courts offers this community.
Roberta, I'm so sorry. I just wanted to chime in. I see your email. I don't see the handout if there's one. Or if
You
there's
don't
a
see the
PowerPoint.
handout. Okay, hold on. Let's try again. Share a screen, right?
Yes.
PDF. Is it sharing?
Yes, I can see it now.
All right, perfect. All right, I told you I wasn't techie. So again, my name is Roberta, and I'm just really here to tell you about the Clerk of Courts Self-Help Center. The Orange County Clerk of Court is Tiffany Moore Russell, and back in 2015, Clerk Russell utilized her expertise in legal services to open up a program that is open to the entire community for a select amount of case types. This is for family law case types, any family law case type for that matter, a small claims case type, which is all money matters under the amount of $8,000, and residential evictions. Certainly, Clerk Russell thought it was important to offer this program and to collaborate with the Orange County Bar Association and here locally with the Ninth Judicial Circuit, because we just realized that everyone is not going to hire an attorney. And guess who realized that first? The members of Orange County Bar Association. There are some case types that people are really and truly going to attempt to represent themselves. But to keep the dockets rolling within the court system, we want to make sure that all individuals interested in representing themselves in a family law, a small claims, or a residential eviction have the opportunity to come down to the Orange County Self-Help Center to obtain some resources similar to forms. You can receive legal assistance by scheduling a one-on-one attorney appointment. Or you can come and use some of the Self-Help Center computers. There are 4 computers there that are dedicated to the Self-Help Center for individuals who are trying to obtain their own diligence, do their own research, but may not have access to a computer at their home. The Orange County Self-Help Center is located on the 3rd floor in the Orange County Courthouse. How do you schedule an attorney appointment, you might ask? You can go to our website at www.myorangeclerk.com and go to the Self-Help Center tab. At that time, you can schedule an appointment for a 15-minute, 30-minute, 45-minute, or 60-minute increment at just $1 a minute. I just keep in mind, we're talking about licensed attorneys here. We partner with the Orange County Bar Association for this fabulous program. So we're talking about seasoned, tenured attorneys who will provide you with some initial advice on how to get started with your case, how to represent yourself in court, how to empower yourself, and answer any questions that you might have about the forms. Notice I said answer any questions that you have about the forms. So the attorneys won't fill them out for you, but certainly you come with your list of questions and they will answer all of them. Well, where do I obtain the forms? You can obtain the forms either online, because we offer the forms online, or you can actually show up in person at our Self-Help Center. Our Self-Help Center is a one-stop shop. We have 5 full-time deputy clerks there. Those deputy clerks will answer your questions. They will triage whatever service you're there for. They will offer you the documents that are for sale for a very de minimis cost. And once you meet with the attorneys or once you complete the forms on your own, they also accept your filings. They're notaries. They will make copies for you. All copies are 15 cents a minute unless you're asking for a court record, which is $1 a page. And our hours are 7:30 to 4:00 p.m. So the Self-Help Center and the 5 deputy clerks at the Self-Help Center are there from 7:30 a.m. to 4:00 p.m. And we offer our attorney services from 8 a.m. to 4 p.m. So again, I hope this helps. in terms of what you might have access to right here locally in your community, free of charge for the service to come in and utilize some of the tools that we have here at the Self-Help Center, and certainly the de minimis cost of $1 per minute in 15-minute increments to access our attorneys. So thank you for having me this evening. I really appreciate it. If you have any questions, please feel free to submit them. Thank you, Mr. Morris.
Thank you, Ms. Walton. And I do want to indicate that I do think that Orange County has one of the best clerks and one of the best programs around. So thank you for all you do.
Thank you. We really appreciate it.
Okay. At this time, we're going to open up the floor for questions regarding family law. Rebecca is going to kind of be in charge of queuing up people. So do we have any questions from the audience at this point? I know we've got a number of people, so I'm sure we have a number of questions.
All right, the first person is Vicky. You can feel free to unmute yourself.
Okay, trying to figure this Zoom out. A lot of fun. Okay, the question I have is, I have a 13-year-old son who does not want to go to his dad's. And I know in Pennsylvania, they have a choice at the age of 12 to pick where they want to live. Is there such a thing in Florida? And if so, how would I go about trying to get that arranged?
Mr. Ferrin?
Yeah, so Florida does not have that particular law. There is a general range of ages where the court, first, let me start. Generally, the court does not like to take testimony in general. They try and avoid that at all costs. We usually use guardian ad litems, social investigators to try and, if you need to get their testimony in, that's how you would go about doing that. So we usually try and go towards those avenues to try and get the information that we need from the children. But as far as just having a child testify because they don't want to go with that particular parent, that's going to be more of an issue because it's generally for modification purposes. So if you're trying to modify time sharing, you have to show substantial change in circumstance. That's not going to reach that level that's necessary to modify the visitation schedule. And generally, many times when you go in front of these judges, they kind of give the same kind of spiel, is that when you tell your child to go to school, they say no, do they just go to school? And so this would be the same kind of view you should have with them going to their other parent's home. If you tell them to go to the parent's home, they should be going there. Now, if there's other ancillary issues going on that obviously we're not privy to, that may rise to a level of modification or may be an issue that needs to be addressed with the court, obviously, yes. But if it's just that they don't want to go for whatever reason, they don't want to go, this usually happens with teenagers a lot of times too, then that's not really going to be something that you're going to be able to bring in front of the court. You're going to have to somehow get that child to go and spend time with that.
Okay, now what if he has just been recently diagnosed within the last 2 years with 4 different mental disabilities. And his dad basically does not recognize or accept that he has these disabilities.
Well, Ms. Krause, we're going to try to keep questions relatively general. I don't want to get into a very specific question that you may want to contact the lawyer referral service about.
Okay, thank you. I'm sorry about that.
Okay, our next question comes from Nala.
I have problem in my work, and I have case in EOC, and I have notes of right from them to file charge, so against my work. And right now I have limit time until December to find lawyer to file so against my work. I looking for a lawyer right now.
Okay, ma'am, what you've got is you've got a labor dispute where you filed with the EEOC and they give you a charge of discrimination, they give you 180 days, usually. What you really need to do is contact the lawyer referral service and see if they can give you the number of somebody who practices in employment and labor law, because we're really only going to be answering family law questions tonight. So I apologize, we can't help you tonight, but we are trying to stick just to family law since that's Mr. Ferrin's area of expertise. Okay?
I appreciate you if you refer me to the lawyer work with my case right now, because
We'll put,
before.
ma'am, we'll put that information in the chat. Okay?
Okay.
And that's who you'll contact, and that Rebecca, can you put that in the chat?
Okay. Okay, I put that in the chat, and right now I stay online with you to complete the
Ma'am, we're
meeting.
going to go on to the next question, okay?
Okay, okay, I will. Okay, thank you.
All right, thank you.
You're welcome.
All right, and just keep in mind, everyone, I will be sending you an email after the session is over with information on how to contact the lawyer referral service and some other helpful information. So you guys will get that in the email after the event. Our next question comes from Stephanie.
Good afternoon, this is Stephanie. My question is, can you hear me?
Yes.
Okay, my question is this. I had 3 kids and we have 50-50 custody with my ex-husband, right? So under the legal paper and parenting plan, it says that for the purpose of school boundary determination, it's only the father's address destination, right? But the father moved from St. Cloud to Windermere. He took the whole entire responsibility for the kids' school district and everything. He just gave me a notice. And the problem is, as a mother, I feel like if we have 50-50 custody, I need to be responsible and choose also what is the best for my kids. So, and my 13 years old daughter shared me that he's want to move again. So when he moved, he think that he had the authority to move the kids for school. For me, that is not stable for the kids, moving the kids to school for another school. And having 50-50 custody, I don't know what to do, because 2 years ago, I just moved out from St. Cloud, looking something near in Windermere to be close to my kids' school. But now it's like I cannot be follow him where he wants to move, because, it's for me, that's not stable for the kids. And I don't know what to do, because he thinks he has 100% custody on the kids.
Well, I mean, so there's 2 things you can do. I mean, you probably want to speak with an attorney to review the parenting plan and to determine whether you have a basis possibly for a modification. Obviously, with just the information you're providing tonight, it'd be hard to say whether you do or not, but you don't want to get an attorney to take a look at that. Or you could try and file possibly a motion for contempt and enforcement of the order. Again, depending on the language, it's in the parenting plan, you may have an enforceability issue where you might be able to file a motion. But definitely, it'd be something that an attorney may be able to help you with. You definitely want to go and speak with an attorney about that.
Thank you so much.
Sorry about that. So the next person in line is Hassan.
Yes, thanks for taking my call. I have, 2 questions basically, but is short. First is, if my income is low, just very low, do I have to still pay my wife the alimony if that's the case? That's one question.
So with alimony, there's a lot of factors that go into alimony. It's not just whether you make more or less than your spouse. The court considers a whole bunch of factors. And actually, in the state of Florida, there is no algorithm for calculating alimony. So, like, for example, if you wanted to know how much child support somebody needs to pay, an attorney can easily figure that out. You just give us the numbers we need, which is usually income, how many overnights you have, whether there's any after school care and health insurance. And we can figure out what child support exactly is supposed to be. With alimony, that's not the case. So alimony takes into a multitude of factors into consideration. some of which are the length of the marriage, the lifestyle you live during the marriage, the income of the parties, the earning potential of the parties. You have to look at all of that to determine whether or not there needs to be an alimony. But the main premise of alimony is need and ability. So if you make a very low income where it shows you do not have the ability to pay, it may necessarily, it may be that your wife has a need for alimony, but sometimes there just isn't the ability to pay. I use an example. I had a case one time where the wife was disabled and she only received, I think it was something like $600 a month in disability payments, but the husband only made, I think, a little bit more than minimum wage, didn't make a lot of money. Unfortunately, that was not an alimony case. That had been married for several years. I think it was 10 or 15 years, but there just wasn't any money for her to be able to receive alimony. So it just depends on, it's a case by case basis. So you definitely want to speak with an attorney to see if there's an ability there for, or if it's an alimony case or not. But you have to look at multiple factors.
It sounded like you had a second part to your question, sir.
Yeah, sorry. So I was in mute. So second part of the question is, I have a house that the loan is in my name completely, and she has no contribution on this loan. So if divorce happens, do I have to give the house, I mean, equity of the house? Is the question clear?
I don't know if Mr. Ferrin, are you online, Mr. Ferrin? Okay, it really depends on a few things. You have to remember that the courts are looking to equitably divide your assets and your liabilities. It doesn't really matter if somebody's name is put on during the marriage. It's, did you own this prior to the marriage? Were you maintaining it before the marriage? Or was it purchased after the marriage?
After the marriage.
And things, and I'm just answering kind of generally, but things that were purchased after the marriage are generally going to be able to be split by the court in half as far as liabilities and assets. And there are sometimes even factors that the court can use to unequitably distribute assets. But generally, they will start with a presumption that things are to be split equally, and then they will look at whether or not alimony is needed.
Perfect. So I know I asked two questions. One more very quick question. I think it's going to help everyone. So we want to file the divorce, with like, amicably, not like don't want to like take this case years after years, but she's not agreeing to do that. So what can I do in that case?
Well, it does take two people to amicably settle a matter. You can, I mean, you will find, and you can consult with an attorney about this at the lawyer referral service, but you'll find that if you can both agree, obviously that's better. You can enter into a marital settlement agreement, have all matters settled before you go to court. But if not, you're going to have to go through the process of filing the paperwork, the financial disclosure, then a mediation where hopefully you can work it out. But if not, there could ultimately be a trial and the court would have to decide. Obviously, everybody does better if you can negotiate it and settle it beforehand. But that's something you, in a specific case, may want to talk to a lawyer about.
Got it. Thank you so much.
All right. Rebecca?
Yes.
Who is next?
So our next person was Scott, but he's not here, so we'll go back to him. But our next person is Tiffany.
Okay, and is Mr. Ferrin back yet?
Yes, he's muted.
Okay.
Tiffany, when you're ready. Oh, there you go.
Okay, I'm sorry. Yes, the question I have is I have got to file divorce and also custody. The parent is in a different state. We have been separated for 3 years now, and there has been no contact or reaching out for visitations or seeing the kids, asking about the kids, anything like that. What and the other parent is in a different state and also works on the road. What are the chances of, if I file for full custody, if the parent doesn't, whenever I file, if they don't default, what are the chances of them getting any type of visitation? And do you think it'd be where children have to come to that state, or would he have to come here to this state?
Okay, first I'm going to double check and see if Mr. Ferrin wants to take this. If not, I will. All right. First of all, the court has to have jurisdiction over a divorce. And so what matters is whether or not one of you has been a resident of the state of Florida. That's just to get beginning jurisdiction. But as far as the children go, there's essentially what's called a home state presumption. A child is presumed to be a child of the state they lived in for at least 6 months. And so depending on when the child moved to Florida, whether the other parent had lived in Florida at all, that will determine whether or not you can file and get a custody order from the state of Florida. That is probably something you do want to talk to an attorney about, whether it's through a consultation through the lawyer referral service or through one of the pro bono clinics. You really should talk to a lawyer about your specific circumstances as to whether filing in Florida is a good idea. If you agree, if he agrees or the other person agrees, then you could potentially file, have a settlement, have a divorce here in Florida, or file and have a settlement in the other state, what other state that is. As far as full custody, people use that term rather loosely. As far as full custody, what they usually mean is majority time sharing. Because when judges are really using full custody, they mean no real shared parenting, and most judges don't like to do that. They like to make sure that both parents have input into educational, medical decisions, school decisions, things like that. So with that, I'm going to kind of turn it over to Mr. Ferrin, who is back. Did you hear the question, Mr. Ferrin?
I did not.
Okay. Tiffany, do you want to ask the portion that's just about full custody again?
Yes. My question was, what are the chances of me getting full custody? The parent does live in a different state and has no contact and hasn't reached out or asked about visitation in the 3 years that we have been separated. And he lives in a different state. He's also works on the road. So I wasn't sure what my chances of getting full custody would be. And then also, if not, do you think the children would have to go to his state, or would he have to come to my state, and how that would work, because they are in school full time here?
Okay. Yeah. So, and I didn't get a chance to catch the answer, but generally speaking, the court's done away with that sort of language of custody, primary and secondary parent. Now we just refer to things a little bit more generalized. We talk about time sharing. We talk about parental responsibility when it comes to decision-making authority and that type of thing. So when it comes to the time sharing, normally when you have somebody that lives a very long distance apart, even if they've been absent for a few years, the court's going to be inclined to do what's in the children's best interest. And that's usually going to be involving
Can anybody else, Miss Tiffany, are you hearing this?
No,
Uh,
it cut off about
It
what he was
froze.
saying.
Mr.
Can you hear me?
Ferrin?
The internet went out. Yes, can you hear me?
Yes, I can hear
Yes.
you now.
Okay, perfect. I'll try and get closer. You'll have to see my big head, but I'll try and speak a little closer. So we refer to it as a long distance parenting plan. And so you'll see very often, where the long distance parent would have a good chunk of the summer, sometimes the majority of the summer. You would see them rotating holidays. So every other Thanksgiving, splitting and rotating the first and second half of Christmas, rotating spring break, and then anytime they can come to this state to see the child with notice, they would be entitled to some time sharing there. But the court's usually going to be inclined to still involve that parent in their life unless they find that it's not in the child's best interest, which very rarely occurs that way. Now, if he's gone or absent from their life for an extended period of time, there may be what we refer to as some ramp up provisions that the court may implement. So for example, if he left when the children were very young and they didn't really get to establish a relationship with him, it may be that, maybe he left when they were like 3 and they don't really know him that well. The court may require some sort of ramp up provisions where they'll require him to travel down, meet with the children here in the state of Florida a couple of times so they feel comfortable. And then once that comfort level has gotten to a point where the court feels is appropriate, then they would implement the regular schedule. So that's kind of how we would see a long distance situation play out.
Okay, thank you. We'll move on to our next question.
All right, our
Rebecca.
next question comes from Moni Rule. I'm sorry, I apologize if I'm mispronouncing that.
Yes, sir. Can you hear me?
Yes.
Sir, I have a question. I have got a property. The mortgage is on my name, but I like to share the property. I like to sell the property, but she's not agreeing on that because she has got some mental health issue. And once upon a time, she was Becker-acted. But in no way she's allowing me to sell the house. Even verbally, I told her that whatever equity I have, I can share with you. But she's not even is not willing to sign the closing paper. So what I can do on that, sir? And I've got another question.
Okay. Are you in the process of getting divorced?
Yes, sir. I'm thinking about that. Unless if she's not cooperating, then I'll have to go for that.
Okay. So there's really nothing that we would be able to give you insight on unless you were going to be filing for divorce. But I will tell you, you mentioned mental health. If your wife is found to be mentally incapacitated, where she can't make decisions on her own, that runs into a whole new set of problems. Because if you file for divorce, what will happen is she's going to have to go and somebody's going to have to go and file a guardianship over your wife in order to help her make decisions. And the court usually will also have a time frame. What's the best way to look at it is like a pause button. Okay, the court is going to stall the divorce for 3 years while it's a statutory provision where if you have somebody that has a mental incapacity, before you can the court can actually declare you divorced, that time period has to pass. And so if that happens, where your wife's mental health is at issue and her mental state is she doesn't have the capacity to be able to contract or reach agreements, that's probably what's going to happen, and it's going to stall the situation out. Now, in the guardianship case, if there's a situation with a house that it needs to be sold, where it's going to lose some equity for both of you or something along those lines, you can try and file a motion in that particular case in the probate court to address those matters and see if there would be some way to sell the house that way. But you run into a problem where your wife's mental health is at issue, where the court may not be able to grant your request at this time.
Okay, sir. And second question is about the alimony, sir. If I go for the divorce and my income is very low nowadays, very low, it's about I'm making some around less than $1,000 per month. Mm-hmm. So I've got one son, and he's adult, 18 years old. But in that case, she's not working, but she has got the working history. working is a record. She has got the license, customary license, but for intentionally, she's not working. In that case, do I need to give any alimony in case of divorce?
Again, I think there was a similar question like this previously. Alimony is based on primarily need and ability. So even if your wife can show that she has a need, she also has to prove that you have the ability to pay. If you're only making $1,000 a month, I would say you do not have the ability to pay, and it's probably unlikely that you would have to pay alimony. I'm sorry?
Okay, sir. Go ahead, sir. Sorry.
Oh, sorry. And it's probably unlikely that you'll have to pay alimony, but it all comes down as well as, I mean, your income may be low right now, but there are ways that people can submit evidence or try and prove up your position as to how much money you're making, whether you are underemployed, meaning that you are not making as much money as you could. These usually involve professionals coming in to do what's called a vocational evaluation. This can be done on your wife as well if she's underemployed, but also can be done on you, where a professional would come in and do a research on the market to determine what jobs are available based on your knowledge, experience, your degrees, and things of that nature. And the court may find that you may be underemployed. So I use this as an example, if you are a plastic surgeon and you normally make $800,000 a year, and just before you are going to be getting a divorce, you decide you don't want to do that anymore, and you want to go and run a jet ski rental place on the beach making $20,000 a year. That's not going to work. Even though you're not making enough money to pay alimony, you have the ability to do so. And so you can pretty much bet that you're going to have to pay alimony in that particular circumstance. So it all depends on the facts in your particular case. But just based on the information you provided, if you're only making $1,000 a month, that does not seem like an alimony case to me.
All right, our next question will be from Yamelis.
Hello, good afternoon. I have two questions. The first one is, what steps should I follow in order to ask for child support? And the second one, till what age a child can receive child support?
I'm sorry, what was the first question?
What steps should I follow in order to ask for child support? What are the requirements?
So is this in relationship to a divorce, a custody case, or you're just asking for child support by itself?
Just child support, because I'm divorced 12 years ago.
Okay. And the individual you're trying to seek support from, is it the father of the children?
Yes, the father of the children.
The divorce didn't address child support?
Yes, but in my country, in Venezuela, we moved to this country several years ago.
Okay. And where does your husband live?
He lives in Atlanta. My ex-husband. Atlanta,
okay.
Yes.
Oh, I'm sorry, your ex-husband. Okay, so he's moved. He also no longer lives in Venezuela.
No, he doesn't live in Venezuela anymore.
Okay. So yeah, I mean, you can try and file an action for child support. You can do that using the Department of Revenue. You can try and have your divorce decree domesticated, and you can try and bring it forward on that as well in the county where you reside. The issue is going to be with regards to your husband having personal jurisdiction over him, but that'd be something you'd probably want to take a look at speaking with an attorney about to determine where to file your case and what you could bring forth. But like I said, you can file it through the Department of Revenue. You can file it as its own separate action, but you definitely can seek child support from him if you'd like.
Okay, great. Thank you.
No, you're welcome.
All right, our next question comes from Luana.
Thank you. I just wanted to say thank you to everyone who's responsible for this seminar. It's really very helpful. My question is, are Ninth Judicial Circuit Court Zoom proceedings available for public view after the final judgment?
Well, I guess that would depend on whether they're recorded. A lot of the trials that I've been doing and the hearings that I've been doing are not recorded. Unless you have a court reporter present for the hearing, the actual Zoom interactions and stuff that we have on the screen normally are not recorded. But I would assume if they are recorded, they would be available. But that's above my pay grade. I'm really not sure.
Okay, thank you.
Sorry, doctor, you didn't answer the second question I made. Till what age a kid could receive child support?
Oh, in the state of Florida, it's 18. And if they're still going to high school in good faith, no more than the age of 19. If the child has a disability, you can request that child support continue past the age of 18 if they're not going to be able to be self-sustaining. But usually the max is 18, and then if they're still going to school in good faith, 19 is the most.
Okay, great, thank you.
No problem.
All right, sorry to interrupt real quick. I just want to say an announcement for those of you who joined late. If you're calling by phone and you have a question, if you just unmute yourself once, we will note it and we will add you to the chat as a question. If your number starts in 942, I did put you in line because I did see you unmute a couple of times. So we will let you know when it's your turn. So if you could just hold tight for a little bit. Our next person in line to ask a question is Etosha.
Yes, I have a question. I've been going through a custody battle with my son's father for 3 years. We were never married. He was married for 19 years and had an affair. We have.
I'm sorry, hold on one second. Hold on one second.
Picked a real good day to have a bunch of technical difficulties. So, all right, go ahead. Can you ask the question again, please, from the beginning?
Okay. I have a 3-year-old son. Me and his father were never married. He's been married for, I think, 20 years now.
Okay.
He had an affair and we had a 3-year-old son. We've been going in and out of custody battles for 3 years. Recently we had a trial where I won't mention the judge's name in Orange County, but her final judgment was for my son to be removed from my house, and I get him 3 days one weekend and 2 days the next week. I'm currently going under appeal, but I was wondering, should I just go ahead and do the appeal or maybe open another case through the courts? I'm not sure.
So generally, once the final judgment has been executed by the judge, normally you've got 15 days to file a motion for rehearing, and then 30 days to file an appeal. Did you ever file the motion for rehearing, or you just went straight?
I filed the motion for rehearing, but financially I wasn't able to keep my attorney, so it was in the time where the attorney was leaving me, so every motion I filed, she basically denied it.
Okay, but you have filed an appeal with the appellate court?
Yes, and they granted it. They told me I had to file a initial briefing.
Okay, so they haven't granted your appeal yet. That's just you've started the process and you have to file your initial brief. So you're going about it the right way. That's what you should be doing. You should be filing an appeal. You do not need to open up a new case at this time. You need to wait for the appellate process to do its work. I would highly recommend, if you have any means whatsoever, to hire an attorney to help you with the appeal. They can be very difficult for a pro se individual to handle an appeal. Heck, it's difficult for some attorneys to handle appeals. So I would highly recommend that you try and find the means to get an attorney. Obviously, that they have the self-help center. I'm not sure if the self-help center does it help with appeals? No.
Yes,
no,
it
doesn't.
it just gives you like a layout of stuff, but if
Okay.
you're not like in the law, I don't understand it.
Well, the Self-Help Center, actually, we don't really do appeals. We really help with circuit cases or county court cases here, handled within the Ninth Judicial Circuit. So now we do redirect individuals to the second floor, to room 210, where they accept all of the appeal filings.
So, but definitely appeals are very complex, and I would highly recommend that you not go it alone. If there's any time to get an attorney, it would be.
So I should just go ahead and try to find me a reasonable attorney to help with my appeal, because I've been trying to do it on my own.
Yes, I would recommend that you try and find an attorney.
Okay, do you typically know how long the appeal process takes, or there's no limitation to
It
it?
varies. It just really depends. It's hard to say. But definitely with the appeals, they're very stringent on their timeframes. You got to make sure you do not miss any of the timeframes or the things that they ask you to do, because they're very stringent on that. Like I said, definitely there's a in the Orlando area there is we have a wealth of very good appellate attorneys in this area, and so you should be able to find someone that
Okay, I appreciate you for your help. Thank you so much.
no problem. Good luck.
Thank you.
All right, our next question comes from Giovanna.
Hello, hi.
Hello.
Hi, I have a case currently that it's an out-of-state case. We have all moved to Florida, me, the 3-year-old child, and his dad, in June. And I wanted input on the possibility of having the case transferred and moved to Florida. We currently just have temporary orders. Nothing's been finalized in the other state, and that's where we are.
Okay, have you already had the final hearings? You're just waiting on the orders to come through?
We have not had a final hearing. We've had a couple of hearings. They were just kind of update hearings. It just isn't moving along on either end. And basically there are lots of things we don't agree on. So we expect some things will go to trial. And I just feel like it would make more sense to do that in Florida.
Understood. So generally speaking, in order for a court to have jurisdiction, you have to have personal jurisdiction. You have to have resided in the state of Florida for at least 6 months before Florida. The problem that you have in your particular circumstances, you have active litigation in another state. I would be hard pressed to say that even if both you and the husband and the father agreed, that court may not want to relinquish jurisdiction until those proceedings are closed. And because that case is going to know obviously more about that court is going to know more about you and your case than a new court or judge here in the state of Florida. So it may be a good idea just to finish it up. And then once you guys are done, then you can ask the court in that state to transfer the case down once it's completed, because being that both of you reside in the state of Florida, you can try and ask that have it transferred now, but that would need to be done in that state. You wouldn't do anything in Florida right now. But definitely, like I said, you have the option of filing a motion to transfer the case to the state of Florida, or you can finish it up and then ask for the court to transfer it once it's done. But either way, it would need to be a request that's done of that state. So you can file a motion.
With the motion filing, I have my next court date is November 4th. We meet the 6 months in Florida early December. Do you know if the motion should be filed in November, or if I'd have to wait for that December threshold where I meet the Florida jurisdiction?
No, courts can transfer cases anytime based on if it's a more appropriate forum, because it's just easier for the parties, that kind of stuff. So you don't necessarily have to wait for the 6 months, but definitely you'd need to file a motion up there as soon as possible. Like I said, in my experience, if you've got active litigation, it's that far along to where you have temporary orders in place, you're getting ready for trial, there's a low likelihood that the court at this time probably going to want to finish.
Okay, and then I just had a follow-up question. We, as part of the temporary orders, and they're just pretty simple, vague, just step up to 50-50 parental sharing time, or whatever that's called. If the father, so this has been ongoing, this started in March up to date. If there are monthly changes to the schedule where he's not keeping the weekends that he has and there's step up, is that basically grounds for modification at that?
Well, I can only advise you as to what would happen here in the state of Florida if you had a Florida case. I can't give you legal advice on a case that's out of state. But if this was a Florida case, first of all, you don't have to if you're talking about modification, could the court change the visitation schedule if what the court implemented isn't being followed even while the case is pending? Of course they can. That's why they're called temporary orders. So if the court has issued temporary orders, the court can always change its order when you go to final hearing. So, but again, that would be in reference to a Florida case. I can't give you legal advice on the case.
Okay, yeah, I think that's helpful for me. And when you say court issued, that's fine if that just also means we agreed to this schedule, and it can't even be kept as we agreed to it and the court signed, right? That means court issued.
I'm sorry, I don't understand your.
I mean, like, it wasn't like a judge gave us this time sharing schedule. We agreed to it and it's not being kept, essentially.
Did you guys sign paperwork? Did you sign a
Yes,
Ferrin?
yes, and then the judge's signature is on it as well.
Then that's
Okay.
as good as an order. That usually
Right.
you file it, and the judge will ratify it, and it's as good as an order.
Okay, yeah, thank you.
All right, our next question is from Taryn. Hello?
Yes, ma'am. We're not getting your audio. It looks like.
Taryn, when you're ready, you can state your question.
Or maybe if her audio is not working, she could type it in the chat, and then you can ask the question.
Yes, absolutely. If you want to go ahead and type out your question, feel free to. If you rejoin, don't worry, we will add you next in line if you get disconnected. In the meantime, we can go ahead and go over to Davis.
Yes, hello, can you hear me?
Yes, ma'am.
Hi, my question is about grandparent rights. I want to know what my rights are in Florida, and I want to know how to enforce them.
Okay, can you give me a little bit of background as to what you need?
Well, my son lives out of state, and I live in Florida, and I'm unable to see 2 of my 7 grandchildren. I did go over there. We were arrested for trespassing. I had to get DCF involved to try to be the co-parent, and I really don't want to go that route. I just want to know if I can have any rights to those grandkids at all.
And you said that where do they live?
They live in Florida.
Okay. So you would want to look at it's Florida Statute 752.
Okay.
And that is the grandparents' rights statute. And unfortunately, grandparents' rights are incredibly limited. They're only really enforceable in very limited circumstances. Just generally from what you're telling me, you probably, unfortunately, wouldn't be able to do anything using the statute, and you probably unfortunately, wouldn't be able to take any legal action from what you're describing. But I would urge you to just take a look at that statute. It's very easy. It's an easy read. It's not very complicated. And it tells you specifically what the factors are that are required in order to.
Okay, and I have another question.
Yes, ma'am.
The other question pertains to a trust. We have family members that live in New York, and there's a living trust. But our family that lives in New York also has property in Sarasota. And I want to know how I can combine the properties in Florida with the properties in New York.
Okay, that's
outside the scope.
Yeah, that's kind of outside our family law scope, because that really goes into real estate as well as trust law. So you're gonna.
So what does it fall under?
It's real estate and trust law. And you can contact the lawyer referral service. They may be able to give you an attorney who can handle those areas, but that's outside the scope of today.
Okay, I appreciate it. Thank you for your time.
Well,
thank you.
Okay, Taryn, we'll come back to you.
Hi, can you hear me?
Yes.
Oh, I'm so sorry.
Florida Statute 7.
Hello?
Go ahead, Taryn.
I think Ms. Davis was asking for the statute 752. or statute 7. Go ahead, Ms. Jane.
Okay, so my question is kind of, I'm not really sure if it's family court or if it's a different type of court. So I have a child support order that's currently in place for my daughter's father. I ended up having another child after that order was in place because we kind of reconciled the relationship. I ended up purchasing a home with him that I'm now trying to get up out of. And everyone's telling me that I need to go through family court in order to add that child to the existing case and to get the that practitioner or whatever it's called to like make us sell the house. And I just thought those were two different cases. So I didn't really know if I was being advised correctly, because I did speak to like a real estate kind of attorney and they were kind of giving me the runaround. So I don't really know what to do.
Is the word you're looking for partition?
Yes.
Okay, all right. So are you guys married?
No, we've never been married.
So definitely with regards to the additional child, yes, we want to file a modification of child support. You want to add that child to the child support obligation. That happens quite often. You're not the only one that went down that road. So that does happen. As far as the house is concerned, that's going to be more along the lines of that's not going to be a family law related issue. That's going to be, from my knowledge of it, you're going to have to, it's going to be treated kind of like a partnership where you guys entered into an agreement to purchase a home, but you're going to have to deal with that in civil. That would not be in family.
Okay, and do you know with the modification, would they modify the current order or would they just add the child to the?
They would, well, you would want to seek a modification to add the child and modify the order going forward so that the child support.
So would they deduct the child support I'm receiving or would they add more?
Well, it depends on what your incomes are now. But,
Got it.
but I would suppose if you're going to add a child, it would go up.
Well, his income has gone down since COVID, so he's not currently working.
Yeah, I mean, you would have to do the math to figure out how that would be. But yes, you would modify to add and go.
And do you have any suggestions as far as getting, being able to file that other practitioner thing? Do you have any advice?
Yeah. I wouldn't be able, that's outside of what we're doing tonight, so I wouldn't be able to tell you that. But definitely you want to speak to the either a real estate attorney or somebody that practices in that general area that might be able to help you with that. But that's not a family relation.
Okay, thank you.
No problem.
Okay, we still have a little bit over 25 minutes left. If anybody has any questions, feel free. You can add your name in the chat, or you can unmute yourself one at a time. If you do still have a question, we still have a couple minutes.
Can I ask you a question, please?
Sure.
Sure. As far as the asset is concerned, how about the native assets in case of the marriage dissolution, divorce decision? How much it will pertain to the assets which we have got from our native country?
Say that again.
So some asset we have got in our native country, the country we are from.
Okay.
So you're the immigrant citizen here. So in case of any divorce, that will be calculated, the asset in their own country?
Yes. So when you file for divorce, part of it is you need to provide what's called mandatory disclosure, and you also have to fill out a financial affidavit. Your financial affidavit declares how much you make, how much you spend, your assets, your liabilities, all of that would be in your financial affidavit. And it's not just in this country, it's your assets, your liabilities. So if you have assets in other countries, you would be required to declare those in your financial affidavit and provide documentation regarding them in mandatory disclosure. It would be considered an equitable distribution, which is what we refer to as the division of assets and liabilities when it comes to the divorce. Now, the court here, obviously, if those properties are located out of the country, this court doesn't have jurisdiction to actually dispose of those particular properties or assets, but it can calculate them and count them in their divisions of assets and liabilities here in the United States, as far as whatever is here. So that the court will definitely do. But yes, you want to make sure you disclose them.
Okay, sir. Sir, if you don't mind, I've got another question. In case of divorce, like I am the citizen of this country and my wife, she is the permanent resident, green card holder. If the divorce takes place in my own country, will it be accepted in this country?
Not if you've been residing here, no. So the court, again, as we previously stated, the court's going to look at where the marriage was last intact, but also where the parties have resided for the last 6 months. If neither one of you have resided in your home country for the last 6 months continuously, then going to your home country to get divorced would not be considered a valid divorce here in the state of Florida. We actually, in my practice, I've come across this issue a lot, and it can lead to some problems because sometimes people don't get the best legal advice, let's just say. And I've heard of people, some attorneys in some other countries tell them, you can go and get divorced wherever you were married, and then that would be valid. But that's not the case. I mean, how many people do you know have been married in like Cozumel, Mexico? I mean, that doesn't work. So the court has to look at where it has jurisdiction, and you would definitely look at where you've been residing and where your marriage was lasting.
Okay, sir. Thank you very much. I really
You're
appreciate it.
welcome.
Okay, we're still open to questions. So if anybody else has a question, feel free to one at a time unmute yourself. If you're calling in and you have a question, right now is a great time to unmute yourself. While we are waiting for another question, I do want to mention, let me turn on my video. I do want to mention that November will be our next Ask a Lawyer event. I'll go ahead and put the information into the chat. It's going to be on Monday, November 15th at 5:30 again to 7 p.m. The topic for November's event will be estate planning, wills, and probate. So let me go ahead and drop that in the chat. Please note that, again, I will be sending this information to you in an email, but just in case you're very curious right now. Another thing I want to mention is in January, we will be having a Divorce Finances 101 event. I will be sharing that information with you guys in the email for the follow-up email. It's a really great event talking about divorces and some things you need to know, whether you're going through the divorce or about to. And I think it could answer a lot of questions that you guys are asking about tonight. So I will share that information with you guys in the follow-up email. But again, we're still open to any questions. So feel free if you would like to unmute yourself. And I'll take a moment to thank both of our speakers, all of our speakers, Roberta, Michael Ferrin, Michael Morris. Thank you so much for your time. We really appreciate you guys joining us. Do we have a question? Barbara, did you have a question?
No, I'm sorry.
Okay, no problem. The event in November, we had a question, is going to be, again, the topic for November is estate planning, wills, and probates. Okay. Oh. And Swilly, did you have a question? Okay. All right. That is, let me see. I'll wait one more second. Swilly, did you have a question? All right. I think that's all the questions that we have for tonight. I'll stay on for a couple minutes if there's any more questions, but we want to thank everyone for joining us. Please keep in mind, again, I will be sending an email with you guys with information that we mentioned in today's event. Also, I will be sending you some upcoming events that I think will be very helpful for you all. We have a question. Are there going to be any way to get help from any attorney? So in the information I'll send in the email will be some ways to contact the Self-Help Center and the Orange County Bar Association's Loyal Referral Service.
Yeah, and if, I just want to throw in that if you have a specific situation, you really do want to contact the Lawyer Referral and Information Center, because then you can get help with your specific case. We can answer general questions here, but in your specific case, there are a number of questions that a lawyer is probably going to want to ask you and find out exactly what is going on in your case. I did want to thank everybody for attending our Ask a Lawyer event. Definitely contact the Orange County Bar Association's Lawyer Referral and Information Service to be referred to an attorney for a free consultation of up to 30 minutes. You may be charged for speaking with the attorney or any services beyond that initial consultation. So with that, I'll turn it back over to Rebecca.
Okay, we do have a question, Swilly. Are you connected to audio? Are you able to share your question, Swilly? I'm sorry, give me 1 second. We do have an attendee who has a question, who's having a little bit of audio issues.
Yeah, it looks like her microphone is not on.
Yeah, she's messaging me that she has a question. Trying to see if she can send me a message for her question. I do want to give her a second just to be able to connect. So I'll give her a couple minutes just to connect really quickly, because I know she has a question. I mean, I think she was having issues with her audio, but does if anybody else has any last minute questions? Oh, I see her joining again. All right, Swelly, do you have a question? Can you hear us? Swelly, can you hear us? All right, you do need to connect to audio in order to ask your question. If you're on a phone, there we go. I see you trying to connect. Can you hear us now? No, could you perhaps type your question because we can't hear you?
While we're waiting on that, in honor of this weekend's game with the Gators.
So Ellie, can you type out your question? Because we can't hear you. I appreciate everyone's patience. I just want to make sure that we can get to her if it's possible, just because we still have a couple minutes left. All right, Okay, I can read the chat. It says, I have a 16-year-old. I don't have any contact with her since March. Because of her father. She doesn't know what to she doesn't know what to do. She doesn't have any contact with her daughter, who's 16, since March.
Is there an ongoing court case, Sueli?
Do you have an ongoing court case? She does.
All right, Michael, do you want to go ahead and?
Yeah, I mean, I'll try. I mean, if
Okay.
we've got an ongoing court case, if the court's already made and already entered an order as to what the time sharing is supposed to be, and your husband's not following the order, you would need to file a motion for contempt and enforcement when it's set for hearing. That should be hopefully a relatively easy issue to fix. If you go to the self-help center, they can definitely help you with that. Even the clerk's office has forms for filing motions for contempt and enforcement. But if there is an order that already states what each of your time sharing is supposed to be and he's not following it, a motion for contempt and enforcement would be.
And if you're having problems with filling out that form, go to the clerk's self-help center. And if you're afraid of your ex-husband, that's a whole nother issue.
And so what I did is I shared the link for the clerk's self-help center. And that's where you can find some more additional information. And so the forms are at the self-help center as well.
Do you want to step in on services for domestic violence, Michael?
You're referring to me?
Yeah.
Oh, yeah, no, okay. No, so obviously with regards to domestic violence, you also have the option of filing a petition for injunctive relief. You can file an injunction against domestic violence. That would be done. It is a family case. It's under the same division, but you would just go to the clerk's office and they'll help you to fill out that paperwork. You can also go to the self-help center as well. If the court in that particular circumstance, ideally what you want to do is when you fill out the petition, you want to make sure you put any allegations that would rise to a level of domestic violence or that it caused you to be in fear of being a victim of domestic violence. There's different kinds of injunctions, but you want to take a look at which one would best apply to you. And you want to go to the court with your evidence, with the dates that the incidences took place, so that you can fill out the paperwork when you're at the courthouse. Once you fill out the paperwork, you'll sign everything, you'll submit everything, and then the court will review what you filed with the court. And if they find that there's a basis, just based on what you've written, that there's a basis for an injunction to be entered, the court will enter a temporary injunction, and then we'll set the hearing out, usually 2 weeks out. And then at that time, there'll be a final hearing where the court will determine whether or not that injunction needs to be permanent or for how long that injunction needs to be, or whether it needs to be dismissed. But I would recommend going to the self-help center. They can definitely help you with that, or the clerk's office.
Yes.
Does that help you, Sueli, understand a little more? Yeah, it sounds like you really need to talk to a specific lawyer about your specific case. So I definitely would take the information they've put for the lawyer referral information service so you can get a referral to an actual attorney. Because if you're saying you've done all that, then there's more that needs to be discussed. Okay.
Yes, and I just shared in the chat the link to request a consultation with an attorney through
Okay.
the loyal and referral and information service. So feel free to do that. I do have one more question in the chat that we can get to, and then we'll probably wrap up. It's what can you do if your kid's father is not paying child support? What are some steps you can take?
So I suppose it just depends on the type of case that you have. If it's a Department of Revenue child support case or just a regular case, you can actually go to the Department of Revenue and they will enforce the order for you. They tend to take a little bit longer than hiring a private attorney, but they do a good job. They're fantastic attorneys, and they can enforce your child support order that way through a motion for contempt and enforcement. Or you can file it on your own if you have a child support case or you have a divorce or custody case. You can file a motion for contempt, or you can hire an attorney to help with that. But that's how you would enforce the child support. As far as enforcement proceedings, there's different things that the court can do in order to entice or urge someone to pay their child support. So they can suspend their driver's license. They can incarcerate them and require them to pay a purge. They can require them to pay attorney's fees. There's a whole slew. But definitely, again, the self-help center is a great source to gather this information, and they can definitely.
Okay, I think they're messaging me that it's a regular case. I believe that's what it is. Let me see. You can let us know in the chat if that answered your question.
Now, even if you mean it's a regular case, so if it's a custody case or a divorce case, you can still refer to the Department of Revenue. They will enforce child support. If not, like I said, you can file it on your own, or you can hire an attorney.
Yeah, the Department of Revenue is relatively inexpensive to enforce those orders.
Yes.
Okay, and okay, that did help. Okay, thank you for that. All right, so sorry, I'm just reading my chat. I apologize. All right, again, the resources that we mentioned today, I'm going to be sending you guys an email with that in just a couple moments. So you guys will have access to that information. I know some of you are very eager to get that information. I will be sending you all the links that I mentioned in today's chat. So you're going to get the information on how to request a consultation with the Loyal Referral and Information Service. You guys will have the information for the Clerk's Self-Help Center. That's where you can go for more information and get some additional help. I think that is all the questions. I'm so sorry that the audio is not working for you.
Yeah, and it really sounds like that person you're talking about, Rebecca, just needs an individual consultation anyway.
Right, and I'll be emailing you some more resources that you can reach out to. All right, I hope that tonight that we helped you guys and answered some questions for you guys. We want to thank our lawyers so much for their time. We appreciate you staying and chatting and answering and getting through all these questions. Again, we appreciate your advice. And I want to thank the attendees for joining us. Again, this session is being recorded, so this will be posted onto the Orange County Bar Association's Facebook Loyal Referral and Information Service. You guys, that's a tongue twister. I'm so sorry, but I will go ahead and add that to the chat. You guys can read it properly. But that concludes tonight's event. I hope everyone has an amazing day. I'll go ahead and stop the recording.